Well, hey, it's another exciting day and another exciting video. Today, it's going to be something that accompanies the previous one I did, which is the FCRA. And this is sort of a hand-in-hand deal. The other one was about dispute letters or reinvestigation letters. This one's a very basic FDCPA letter that one uses at certain points in debt collection activity when initiated with the 1692G Dunning letter. Today's video is given under the auspices of education, information, and a little bit of entertainment. I try to throw something in there. I don't have any jokes or anything, but hopefully we can get through this in less than 30 minutes and give you lots of information. And now here's the first funny thing. Today's video will be brought to you by ass. What does that mean? You'll find out later on in the video. I want you to keep in mind at the end, we're going to be talking about cease and desist letters, but the cease and desist letter is also inside the meat of this act today, which is the validation letter and how do we send one. I want you to also think about the interplay of something I talk about regularly, especially because collection lawsuits are account-stated lawsuits, generally 99 times out of 100, unless it's Citibank collecting on the specific agreement that's attached to the lawsuit. It's usually an account-stated statute somewhere or another. And another thing, the application, okay, so a collection lawsuit and a collection attempt, in some senses, are two different entities. Although the FDCPA talks about initial communications and whether a pleading that's collecting a debt, in other words, a lawsuit, is a collection attempt. According to 1692D, it isn't. But I'm going to show you how that's incorrect. Oftentimes, we take as gospel what is written, and you're supposed to. Congress creates this great FDCPA statute, and we just follow along with it. But legislative or agencies or departments of our government mess with stuff like that all the time, even though Congress is the rulemaker, the lawmaker. The departments are the rulemakers applying these or interpreting. But also judges interpret statutes. We just have the discussion the last video. You got this great little statute that says all you need to do is show that a violation occurred and you win. But to let the three ultra business judges came into the Supreme Court, got another two people next to them, and now they've made it so where it's no longer a strict liability or violation of a statute is enough. You now have to show damages with some exception. So I say all that because today's video is about somewhat the CFPB's interpretation and their attempt to do a good job for consumers that for years have complained about certain things that debt collectors have done in spite of the rules against that, or where there's a gray area. I mean, that's what people do, that's what lawyers do. Lawyers protect against the gray area. They use the gray area. Laws are half the time, they're solid suggestions, but even the governmental agencies and our courts, there's a separation of powers, but that doesn't stop certain companies branches of our government that are supposed to be separate from going in and messing with stuff. So that's woo in the weeds. So in November 2021, well before that actually, the CFPB made its final changes as to the FDCPA. It had been receiving a lot of complaints, so it decided to do something about those complaints. So one of its main focuses was on the validation letter. What's a validation letter? A validation letter is your right upon being collected upon to seek validation. It's as simple as that. I dispute this, prove you have a right to chase me. That's due process, actually. That's the very heart of why America is so great, is our due process rights. Otherwise, someone can just come in and say, I'm Bob, you owe me the debt that you owed Steve, and pay up. Now, debt collectors must accompany any attempt, well, not any attempt, and we're going to talk about that, and their first attempt to collect from you with your rights to dispute that, which kind of makes sense. So what the CPFD did, and I'm going to talk about those changes today, I'm also going to talk about why they were wrong. Me, little guy, what am I, 5'8", 162, and I'm going to tell you why that big, huge, more powerful than me, maybe, more powerful than you, definitely not, you're the people. That organization, the CFPB, which I love, it's been gutted somewhat, made these rules which I can see are wrong in certain states. And we're going to be sort of Michigan-centric today, but you'll understand. So just think my most powerful thing that I always preach, which is the counter affidavit. You've seen my videos, how to produce a killer affidavit. Well, it's going to kill the government today. So let's take a look. One of the tips when you are validating a debt, so quick background, is it's about the person, not the debt. So don't get in your head, here's a debt, how much? Are you the right person being collected upon? That's really what courts ask. And then secondly, they say the creditor. Who's the original creditor? So focus on that. By the way, you're going to see my letters, how I think the letters should go. And if you ignore my letters and just follow what the CFPB says to do, you're okay. But I'm going to show you today why my letters are better. And when I say my letters, my validation letters that go back to the collector say, hold on a second, before you go any further, prove to me I owe you. So it's not about the debt, it's about the person. Judges, other collectors that are coming after you, or collectors that are coming after you, attorneys, they don't like your rights, meaning their focus is, hey, you owe this debt. Now you're trying to get out of it. I pay my debts, and you're validating. What does that mean? Well, it's your legal right to do that. And as Congress created this rule, this law in 86, because there was so much abuse by the very people that are now saying, hey, what are you doing? You owe this debt. So always keep in mind, no matter what, as I said in my last video, even when you can show it's a complete identity that you had nothing to do with it, they're like, nah, you owe it. So the focus is on you, the person, not the debt, although the debt is important. And the other focus is, does the collector have a right to collect the debt by virtue of servicing or collecting for the original creditor, or they bought the debt? I want you to remember today I'm going to go a little bit note-centric because it's a little tricky about the changes. And I'm always weird about, like I did a video on just this topic, but smaller. And I look back and go, I missed a couple of things there. So I'm always trying to not look at notes, but today I'm going to try and look at you as much as I can. But there's the validation period. The validation period starts on the date that a debt collector provides validation information required, meaning they've written to you and said, you got 30 days. And so you have 30 days to respond and dispute, or respond with a dispute seeking verification or validation. And those two words are used. It isn't just one or the other. And that's a very common thing these days. So the CFPB came in and went into that validation period in a way that doesn't make any sense. You're going to see what I say. And again, remember ass. But incorporate in any validation request you make. It's a automatic initiation of your right to have the debt not be collected upon. 1692 GB says when they receive a request for validation, they, meaning the collectors, must cease all collection efforts. So I talked earlier about the interplay of lawsuits and collection attempts and how they go. So do they stop suing you? And the answer is no, they're not required to stop suing you. But if you're a Parker student, and that's everybody, just listen. I'm not your attorney, I'm giving this general information, but I can show you today, and I'm going to be showing you letters from collectionstopper.com, my podcast plus section, and with my magic Shazam, I will put the letters that I'm talking about today. There's going to be a couple of letters. There's going to be my validation letters. Remember, belt and suspenders. I don't just have the belt, I have the suspenders. You're going to see what the CFPB has suggested is a role model, a model form letter, which every debt collector now is using because they see get out of jail. It's called, in the law, whenever you want a company to do a thing, a court or a legislative body will say, here's a safe harbor thing. When collectors or corporations hear safe harbor, they moth to a flame. And that's a fitting analogy or metaphor today. Don't know, always had trouble with those. And then you throw in a simile. But I think following the CFPB can get you in trouble in this aspect with someone like me and my students. And we're going to find out really quickly why. So there's a cease and desist component to the validation request. My letters have exactly that, but that's the law. They have to cease and desist once they get the validation request. And it makes sense because the policy is, what if the person collecting upon you is not the right guy or they made a mistake? So you should not be subject to collection attempts till your right to seek validation is listened to. So my number one big tip in the last video about FCRA and dispute letters was keep a paper trail, register by mail. That's the same here. When you're sending anything to anybody in a collection situation, keep a paper trail, register by mail. Whee, that's gone. So two big changes that the CFPB, the Consumer Financial Protection Bureau, made with the validation rights that you have. It used to be where it's all in writing. Now a collector, believe it or not, can call you and go down all your validation rights, meaning they can tell you everything. The creditor is, the amount is, this is how much you owe, this is when it was charged off. They can do this verbally. And that's an area I can see that can be abused. I'm going to show you today that a debt collector, whereas there were a number of cases where repeated calls would either cause a person to lose job or get anxious or go crazy. There was a case in California brought by a company called Morgan & Morgan, not California, Florida. And the guy died. He had a heart attack because of the frequency of the calls and the anxiety caused by the collection calls. It just freaked him out. And there's an axiom or a rule in tort law that says you take the plaintiff as you find him. So the fact that this guy was super sensitive and was easily triggered, we don't go, well, if he wasn't stronger. No, you take the plaintiff as you find him. So if that person had issues and you triggered him with that behavior, you're liable. And we will, again, back later on, we're going to talk more about the cease and desist. So the things that, again, there's a codification of a rule. So 1692G is the efforts of the legislature to provide validation protections for consumers. So they codify, they write the rule. The CFPB interprets it or provides rules that enforce Congress creates a law, they create rules that are supposed to continue the purpose and spirit of what Congress is trying to do. So the CFPB increased the amount of things that must come your way if you seek validation, or if the collector says, I'm going to try and do this verbally, so I don't have to go through this stuff. And they must provide now debt collector communication disclosure, name and mailing information, name of creditor. Here's the big one: more itemization of why you owe and when you owe it and when you made the last payment. The account numbers. Debt buyers will hate this because account numbers are where they fall fast, because they're paying pennies on the dollar and getting some really bad paperwork because they're paying pennies on the dollar for debt. Itemization of the current amount of the debt, when the debt was charged off, the last payment, and those two are important, but were never the requirement of the original rule. And now here's where I get kind of weird with the ass. That just sounds bad. You'll see. I should explain that. So ass means account stated statute, ASS. I got to stop saying ass and then have you think, well, I'll just wait to see what he's talking about, because I may get a lot of views if I keep saying that word. Hey, maybe I should do that. Anyway, so the right to dispute has a 30-day component. You heard me talk about that. It's called the validation period. So when you get a letter, you got 30 days. The debt collector doesn't sit there for months hoping that you validate before it can do anything. You got 30 days. They don't really have a mandatory amount generally to get back to you. And it used to be in the old days that if they didn't get back to you like 20 or 30 days, you knew they were just going to throw the debt away or give it to somebody else. The consumer's right to request original credit information and the date validation period are three things that the CFPB focused on, where I have a problem. And I will tell you why very soon. In the model letter that the CFPB created this safe harbor model letter that debt collectors now use. I'm going to give you an example. This is an actual letter for a person, and I took off the names, but there's some dates I want you to see. So Shazam, that's the CFPB letter in action. That's a debt collector. Weltman and Weinberg has used the model form because it's a safe harbor. They know if they do it this way, then they can't be accused of breaking the law. By the way, I didn't read everything, but there's also requirements of payment disclosures, debt collector's telephone number, safe harbor. There's some optional content, that's optional. Spanish language disclosures, consumer response. Some of that stuff I told you, it's too much. So I have yet to see this whole thing in a new safe harbor letter, but no one's saying anything. But I will tell you this. I'm going to put that letter, the CFPB letter, on the screen again. Shazam. Look at the date. And look at the date. July is when the letter was sent. But look at the date when they're telling you to write, you must get a validation thing back to us. Do I have it anywhere? Yeah. The actual letter. Yeah. September 4th. We must stop collection on any amount you dispute until we send you information that shows you the debt. I have a real problem with that. When I read you the validation date, you have 30 days. That's codified. That's the law. You don't have 45, or you have maybe 31 if you keep in mind what an actual day and a date is. So you got 30 days to get yourself out of jail, at least for a little while, and delay things. But then every letter, the safe harbor letter, has extended the thing. Like in the letter up here from Weltman Weinberg, extends it almost a month. Absolutely a month. No. They're adding some days on there. They aren't supposed to do that. And I can see them saying, "Oh, you missed the 30 days." And you say, "Well, your date said I don't have to get back to you till September 4th. It seems like people are getting set up by that. So I don't know why that model letter is like that and is promoting that. So the ask component. The ask component. Now, the words "the ask component" can be on the end of some statement in any movie. The ask component. It's a secret agent, or the ask component. Is it a donkey? Is it an ass? And then there's other ask components which we won't get into. But here, an account stated statute, all right? It requires that you have an account. The account stated statute says, if we attach an affidavit to a collection lawsuit, you're toast unless you counter with your own affidavit saying that's wrong. In fact, and it even goes one step further. If you do a counterclaim, and you use your counter affidavit, and attach it to your counterclaim, they only have a certain amount of days to respond back to you, or they lose the counterclaim. So with that in mind, we're now told that this debt collector is suing us. We're going to respond, and yet there are a certain amount of days that the debt collector has the right to respond. Even if you believe the collection of a debt and the suit of a debt are separate entities, they're not. Because if you've countered with a counter affidavit, you've put the burden back on the collector to, and you send a validation request. There are a number of days which are different from each other. The account stated statute, I'm delaying here because I'm screwing it up, and I have lost what I wanted to tell you. The account stated statute makes an effort to show that you don't owe this debt. They are saying you do owe this debt. Where I'm going with this is put the letter up, the CFP letter, the Weltman-Weinberg letter up. If you go to the bottom, if you're looking at it, it's your bottom right. It says, how do you want to respond? I want to dispute the debt because I think this is not my debt. The amount is wrong, or other. Well, the account stated statute requires you to do a counter affidavit saying it's not my debt. And here's all the reasons why I dispute. So I'm good with that. If you say either in the account stated statute or here, I'm disputing because the amount is wrong, and you didn't do an account stated statute affidavit, you lose, because the account stated statute, and I hope this is clear, generally says you've got to say, you've got to counter what we're saying. We're saying we own this debt, you owe the debt, regardless of how much. And to just check off a box, the amount is wrong, that's not a solid way to dispute a debt. It isn't. It might be peripherally for what the CFPB is trying to do. But unless you do an account stated statute saying, I don't owe this debt, I'm not liable, and I don't owe the amount, it's going to be left to the courts to go, well, she disputed it because the amount is wrong. That's not solid enough. And we've talked about the summary disposition motion. Is that material? Is it a material dispute of why you don't owe the debt? No, the amount is wrong is not a material dispute. So I would argue in this new letter that all the debt collectors are following, the model safe harbor, it's not enough if the client doesn't also have an account stated statute. This is not my debt is pretty solid, but I don't know if the account stated statute is being disrespected here, but there should be more in this letter, especially when it comes to Michigan and Florida and states that follow a heavy requirement that if there is a collection attempt through a lawsuit, you must come back with an account stated statute. So someone's going to say, well, Parker, those two are two different things. So where I'm going with this is two different things, meaning a collection attempt is not a lawsuit. Those two, and the FDCPA, as I said, 1692 GD says a lawsuit is not a pleading. So it's also not an initiation of a debt. And generally, how you get collected upon and receive your validation rights to dispute are with the initiation. And Parker, you're wrong, because the statute, FDC specifically says, no, Charlie, a pleading is not a collection attempt. But what a lot of debt collectors are doing now, when they sue, in particular, there's a company here, but it's a model of it, what everybody's doing now, and Midland Credit Management does this. They'll do the lawsuit, they'll have the pleadings, caption pleadings, why you owe it. And on the bottom, they'll say, this is a debt collection attempt. Anything you say will be used for that purpose. And especially, the law firm sometimes will say to me, oh no, we put that on there. Well, then that's an initiation of a collection attempt if that's the first time somebody receives a pleading. And they'll say, no, it's a pleading. It's not an initiation. I'll go, yeah, it's not an initiation for the plaintiff, but you're not in the lawsuit. Conversely, Citibank is not a debt collector. Although if you watch my securitization videos, it is. And that's another thing. The CFPB had an opportunity here to do something with something that's really powerful. I didn't see the word securitization in the new rules. It really placed the burden on the debt collector to come up and go, yeah, it's securitized. This is a real big hole again that I see. So I counsel all my students and clients, place the words, if this was securitized, please show me who was in the trust, were the receivables transferred, because they all are. So back to what I was saying about Citibank. Stanger and Stenger represent Citibank, and yet they'll say, we are debt collectors, anything you'll say will be used for that purpose. There's two reasons why they're doing that. Number one is because, see, this is a Citibank one. Put up the, we're going to Shazam, Citibank lawsuit, and on the bottom, go to the bottom, you'll see, we are debt collectors. Well, if Citibank is collecting on its own, they're creditors. So by virtue of the statute, they can't be debt collectors. But here it is. The lawyers will say, and I know I'm going in the weeds here, but just try to get some of this stuff. The law firm will go, no, that's us. But 1692E11 says, all debt collectors, when they initiate or contact, must say they're debt collectors. Their initial contact must give the validation. So 1692E11 says you got to do that, except it says debt collectors don't do that in a pleading. So they can't say that they're putting this in the lawsuit and it's got nothing to do with Citibank in this case, because the law says they're not supposed to do that. Are they admitting they're breaking the law? So why is Citibank having we are debt collectors on their paperwork? So there's a lot going on here. And again, Citibank, as you know, is securitized debt. And so they are third-party debt collectors. So I'll come right in the court and go, see, it says that because Stenger's not in the case and it's against the law for Stenger to do this. So Citibank's admitting it's a debt collector. And now I can go after them under the FDCPA. By the way, you think Citibank send a letter to anybody saying, here are your debt collection rights? Hell no, not once. And they sue thousands of times a week. Imagine what's going on here if they securitize. If is not a word in this situation because they did. So they are debt collectors not validating a debt. So I'm nailing the law firm for not sending the 1692 validation rights if they haven't yet contacted the client, because they're saying they're debt collectors if they want to say that. They're damned if they do and they're damned if they don't. And then Citibank should have done it too because they're debt collectors. It really messes things up, and it should. Congress missed the boat here by not talking about securitization because nobody takes it seriously as I do, but it is the law. It is what securitization is a good thing. It gets rid of old debt so that major banks and companies get it off their books so their rates come down and they get more money to lend to people buying houses or buying cars. So it's good for the economy. But they also use it to raise money. They sell the debt to raise money to improve their facilities, improve their AI, improve their security. It's how they do business. It's a large part how, if you look at any of the 10K or the financial reports of the major JP Morgan, Citibank, Bank of America, they heavily report, we have to securitize. We need to raise money to pay old debts. I think I was reading a Bank of America, like, we just got sued in a class action. It's just, they have to report this stuff in writing, legibly, to their shareholders that are making decisions, that are voting by proxy. So they have to be honest about everything. And they heavily go into securitization and its benefits. How come it's not mentioned in a very important place? I don't know. So the end of the validation period is 30 days, but the model form letter, in this case, Shazam, the Weinberg letter here, has greater than 30 days when you're supposed to get back. They could play games with that. It isn't enough to say, well, we told them and that's... No, why would they not follow the law? They're literally breaking the law, and I don't see anywhere in the CFPB changes saying, sure, add 4 days. So that's a problem I have with the new rules. So how do I fix that problem for you and for the rest of the world? Here is how the Shazam, boom. That's how the letter should look if you want a belt and suspenders. That's a Brian Parker letter. I've touched everything, including securitization, so that they're not required to answer that question, and you aren't supposed to ask that and then suffer defeat because you didn't ask that. But if the debt was securitized, that's part of an assignment. So who is claiming to be the creditor if there's a gap in the chain of title? Because securitization is a chain of title, meaning you assign the debt to the trust and they either sold it to somebody else, or, as their own rules say, to their benefit, if a person defaults on their credit card, it gets assigned back to the original creditor, or what's called the originator, which, let's say it's Citibank. But they never do, because nobody of the millions of debts is going to go, let me get the Smith debt and write up an assignment. There's actual forms in what's called the pooling and service paperwork. And it's codified in everybody's rules saying you must assign the debt back to the original creditor if it goes through default. I don't recall if there's anything about paying the money back that they used and gave to people, blah, blah, blah. But they don't do that. It's just, the machine is not set up for that. So anybody that's defaulted on a debt, let's say it was Citibank, Citibank has no business coming after you, because at least part of the debt has been sold off And unless they provide attached to the lawsuit proof that it was assigned back, then they don't have a right, they don't have standing. It's really in the weeds, but in a court of law, it's quite simple. If you get a chance, just put in Google, Citibank 10K financial reports, 2018, and then go Control F. And you'll see there's a process. It'll say securitization of credit cards. And you can see exactly what I'm talking about. They have to tell you, forms and everything. So that's a major component of a Brian Parker debt validation request. Let me put it on the screen again. Shazam! That's how it should look. Belt, suspenders, rope, sewed into your skin. Those pants are holding up. I've got this. I've got it for you. If you want to do the best job possible and then hold these guys accountable for not following what you asked for, that's the letter. So the interplay of collection and which are separate from lawsuits by virtue of the codification of the FDCPA isn't so separated, especially when they screw up. How? By putting on the bottom of their lawsuits, we are debt collectors. Why do they do that? I've spoken about that before. Because they're always covering their ass. They're always worrying about me or you and lawsuits. So they throw in the kitchen sink. Well, early videos for me, especially in how to defend against a debt collection lawsuit. You volunteer anything, you're going to be suffering worse. Don't volunteer. Just telling you legally. I'm not being a mean guy. And by adding stuff on, look at the stuff that I got out of that. By the way, I didn't touch upon something with my FCRA video, how to dispute a debt. But when you dispute a debt, especially on your credit report, it's disputed. What do I mean? Well, that is in your FICO score. So if your FICO score is 650, a collection debt appears on there. By the way, the new rules also say they're not allowed to put that on your credit anymore. They have to verbally call you up and talk about it. I swear. So this is the rule is before they then put it on there. Although the rule doesn't say we're going to put it on your credit. So who knows? But when it does appear, your credit score will come down. Well, if you dispute the debt, which is your right, and you're right about that, then you just lost 50 points on your FICO score. Your interest rates go up, and maybe you don't get the debt or the car or the house you want because of that collection debt that hasn't been validated yet. So when you validate or even dispute, that debt is now listed as consumer disputes debt and cannot be part of the mix creating your FICO score. So think about that. Let's say it takes them 30 days and you want to buy a house within the next 30 days. If you have a right to validate, technically you can pump up your FICO scores. And if you can't, because they don't take it off, even though you have proof of dispute and you have to pay higher interest rates, boom, you've got damages. Because if you dispute something, just as you can't be collected upon because it's in dispute, it should not be on your credit report. Think about that. It's not complex. You can go get some debt within that 30 days until the dispute, or your score should come down, your score should go up or remain up, and your interest rate should be lower and not what it is with the collection attempt while the dispute is being worked on previously you've got a green card because you followed Parker and you sent this stuff, keep a paper trail, register by mail. So this is valuable stuff. And I'm mixing FCRA with FDCPA for your benefit and your client's benefit. They went into time-barred debt, but the change really wasn't there beyond what they were supposed to do. Don't sue on time-barred debt. As always, you can still pressure someone for a time-barred debt. You just can't sue on it. You just got to be more open and obvious and say, which everybody was doing anyway because of some Seventh Circuit case saying this debt cannot be sued upon. They got to say that in the letters. So the CFPB didn't really do much there. I want to start speeding through this. There's a thing that I've done a couple of lawsuits on, and I'm still kind of mad about. It hasn't gone anywhere. But there's only 6 people that can look at your credit report. That's the consumer, you, the consumer's attorney, a consumer reporting agency, the creditor, the creditor's attorney, or the debt collector's attorney. This has an FCRA component, but third parties have no business knowing about your debt. So if they go next door and bang on your door, on your neighbor's door, and tell them, hey, she owes a debt, that's a violation of 1692 CB. I want you to be aware of that and then think about that when a process server is coming up and serving you with a debt. And I was reading it and tells you, hey, man, I see you got a medical debt there. Well, who gave that guy a right? He has a right as a process server to serve you, but he's not one of the 6 exceptions. Now, debt collectors will say he's got the right of express permission of the court, which is a subsection, but he hasn't. Process servicing is not created by a judge. It's a court rule that has to be expressed. Go serve Mary Elliott this by order of the judge. So that's a side note. I don't know why I really threw that in there. Good little tip. I'm going to put Brian Parker's validation request letter again, Shazam, up on the screen. I write, hey man, if you don't follow through with this debt after I asked you to do something and I've disputed it, tell the next debt collector. It's a huge burden. No one's required. The CFPB rules really don't address it before or after. The FDCPA talks in terms of disputing a debt. But there's case law that says if you have a debt where you were aware it was disputed and someone sought validation, you have to be told that debt buyer of another debt buyer. And frankly, a debt buyer will not buy debt that's been disputed by a consumer because that has with it all connotations. They fear that there's validation issues. And it has no value to them if a consumer says it's not mine. Why are they buying this debt and chasing these people? So there's several cases that say if a debt collector is aware it's been disputed, they must tell the next debt collector. And so you have a case against the original debt collector if this new debt collector comes in and starts collecting from you. So that's just another where you're kind of pissing the debt collector off. Put that in your letter like I do. All right. We talked about how lawsuits and collection attempts do not mix, but they do. By virtue of the law firm putting right in their lawsuit for somebody else. They're not a plaintiff. They're not a party saying we are debt collectors. So again, the rule is an initial pleading is not a pleading is not initial communication or a collection attempt. Therefore, there's no 1692G validation rights. But when the debt collector, which they are all doing now, puts we are debt collectors, anything you say will be used for that purpose, which 1692E11 says don't do, specifically says don't do, then you've made the collection lawsuit a collection communication. So therefore, whoever receives that lawsuit has 5 business days under the law to receive their validation rights. If the debt collector is not sending you a letter and is just sending you the lawsuit to avoid that mess, that debt collector putting that in the lawsuit maybe put Citibank on the hook for under 1692G and put itself on the hook. So they get double whammied while they're trying to protect themselves, because in the law, you never volunteer anything. It ends up hurting you. So let's end up hurting them. I just want to touch on what's a mini-Miranda provision. That's the actual statement that says, we are debt collectors. Anything you say will be used for that purpose. Also, remember, right now, a law firm called Dubestein Law Firm, they collect for UHG, Midland Credit Management, and they have their own lawyers doing this. And Stenger and Stenger, all three large output collection lawsuit firms, all putting "we are debt collectors," anything you say will be used for that purpose. I am slamming them with that. You should too. So that goes in terms of what clients will say. They go, "Hey, I sent a validation letter and they sued me." Well, yeah, they can do that. It stops a lot of things. It stops collection attempts. So I would argue the rule is 1692 GB says once the debt collector receives the collection validation request, cease and desist. But if they sue, and they are allowed to, that's not a collection attempt. But if they put "we are debt collectors," anything we use for that purpose, or the mini-Miranda right in the lawsuit, that is only showing up in a collection attempt. So they have breached and broken 1692 GB, which says "thou shalt cease and desist collection." Remember, again, the reason why they have to cease collection, because until they prove they have a right to, which they may not, we want to make sure that, and they want to make sure they're collecting on a debt that they have a right to. So they breach that. So collections and collection lawsuits are separate entities until they provide a volunteered bridge to their own deficit. So that's that. Talked about that. So we've talked about, securitization. That's the golden triangle. That's the intangible there. That's the Death Star, I think, to collections as we know it. And it's the Death Star to this validation thing being tightly buttoned up as though they're really giving consumers greater rights now. And in some cases, they're going against the actual law that Congress created, not talking about securitization. You should. Cease and desist letters, very simple. Let's put a cease and desist letter up. Shazam, that's my model cease and desist letter. It's yours if you want it. It's on collectionstopper.com, podcast plus. I am hurrying now. The thing about cease and desist letters are a great idea. Let's say you're getting hammered and they just won't stop calling. A cease and desist letter, and you send it. Return receipt requested. Keep a paper trail. Register by mail. If they breach that, if they keep calling you anyway, you got a great lawsuit, right? So I just want you to remember also, if a debt collector is calling you or sending you letters and you send them a cease and desist letter, which is your right, they may sue you because they perhaps go, we tried everything else, we're not going to have to sue this person. They may not want to, but just be aware of that possibility. Also, if you're getting calls at work, that letter, Shazam, cease and desist letter, should say, "Don't call me at work, and here's my phone number." So don't just send a cease and desist letter and no address or no phone numbers. Show them the numbers that you told them not to call. You may end up having to show in court how bad these guys were. Remember 1692E8, which is an FDCPA component regarding communicating or threatening to communicate to any person credit information that is false. So if they put on your credit a collection account, this guy argues totally wrong, and it goes in terms with what we were talking about with impermissible purpose doctrine. These debt buyers don't have the proof. They don't have the assignments, baby, to go from the creditor to this guy, to this guy, to this guy, to the guy that's actually pursuing you and now puts it on your credit report. So I would argue impermissible purpose and 1692E by placing inaccurate, false information on your credit report. So look that up. 1681F, I believe is the, I may be wrong about that. F or B is the permissible purpose doctrine, and 1692E8 is the area covering your rights not to have something false on your credit report. Remember, too, if you're going to do a lawsuit, have damages. If you're sending certified letters, you're paying for those. Those are damages enough. You're paying for an attorney. Those are damages enough. So, and that's the new rule as far as getting standard in federal court. You have to have damages. But there are exceptions to that, but you don't want to go down that road. Remember to go to my letters in Podcast Plus. You've seen the letters that I want you to focus on. They'll be in Podcast Plus, along with other letters from pre-CFPB times. You can still use them and conform them. They're all in Word. It's all free. It's all there for you. I think that's it. The other minor thing is in my letters. Let's put up one more time my validation request letter. There's a component there telling them I dispute my credit. Belt and suspenders again. Belt and suspenders. So I want to thank you today for stopping by, and I hope this is helpful. I know it went long. There's a ton of information there. If you just pick and choose, that's great. I want to thank you, though, and if you like what I'm doing and want to see more, comments. Just say, Parker. So that last one I did, which has gotten a ton of views, more per day than I normally get, is directly from, I think, a gentleman named David, asking me to do that. So I'm doing this one to accompany that because it's such a, if you will, that word again, interplay. I'm glad I explained the word ass for you, the ass component. That won't be in the title, by the way. So like and subscribe. Go to collectionstopper.com. Anything you want from me, give me a comment. My email address is somewhere in there. But like and subscribe, and I very much appreciate your time today. Thank you.